Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 64. In this podcast we're going to be looking at 3 EAT decisions. We've got a clutch of EAT decisions for you. The first case considers whether an employee had affirmed an employer's breach of contract by continuing to accept sick pay, amongst other things. Second case looks at the jurisdictional scope of employment tribunals in respect of claims brought by employees who've made a public interest disclosure, a whistleblowing complaint in a sense. The key question that the EAT considers is whether the jurisdictional scope of employment tribunals should be different for claims where there is a public interest element rather than an ordinary unfair dismissal complaint. Thirdly, we have a slightly unusual case which focuses on the amount of compensation a job applicant ought to receive where the employer has subjected him to victimisation, and the EAT looks closely at the extent to which the compensatory sum should be reduced to take into account various surrounding factors. And finally, I just want to follow up on the YouTube launch of the podcast, which is taking place alongside this episode. So first up, Colomar Mari and Reuters Limited. Just a quick reminder that the names and links to all the cases can be found on my Twitter account, and details of that, it's Nicholas Robber, Rober11, at twitter.com. Do have a look at that and follow me on Twitter, but not least because you'll get a variety of the links to each of the cases that we refer to in this podcast. Anyway, back at the Reuters case. This is an EAT decision which looks at whether an employee can be said to have affirmed an employer's contract and waived effectively the breach of contract by continuing to accept sick pay, amongst other things. And this is a really important issue. It's not an arcane area of employment law by any means. Employers and employees both need to know what the position will be if an employee goes off sick, perhaps claiming they've been treated adversely immediately beforehand. Is the employee expected, for example, to resign if they claim there's a constructive dismissal whilst they're still off sick? And this case gives some very helpful guidance on the area, whilst indicating it's still going to be quite a tricky area. Key facts of the case were that Ms. Mari was employed by Reuters from October 2004 as a systems support analyst. She was off work with stress, anxiety and depression from May to October 2008, and then again from August 2010 until April 2012 when she resigned. Ms. Mari claimed that the initial period of sick leave was due to her unreasonable workload and she had suffered abrasive management. Her second period of sick leave, she claimed, was due to having been allocated a role that was below her level of expertise. She was overlooked for training opportunities, and her grievance hadn't been dealt with satisfactorily. And finally, she was refused access to the IT system to deal with a query that was within her area of expertise. During the subsequent lengthy period of ill health absence, Ms. Mari received contractual sick pay until it expired after 39 weeks. During her absence, she was seen by the employer's occupational health, and on 3 separate occasions she asked for her email access to be restored to her. Also, during this time, Ms. Mari wrote a letter to Reuters explaining that she felt she'd been treated badly, but she wasn't well enough to deal with the situation right now, so she was, quote, considering her position, unquote. Well, 8th of April 2012, many months after she'd first been absent on the grounds of sickness, Ms. Mari resigned. In July 2012, she brought proceedings against Reuters on the basis she'd been constructively dismissed and claiming discrimination. At the tribunal hearing, the tribunal considered Reuters' argument that Ms. Mari's claim for constructive dismissal could not succeed because she'd affirmed the contract. And in order to make its decision, what essence was a preliminary point, the tribunal had to take Ms. Mari's claim at its highest, i.e. it had to assume that Reuters had committed a fundamental breach of contract, which entitled her to resign. It then proceeded to hear evidence as to whether Ms. Mari had indeed affirmed the contract. Now, her main case that she relied on was the severity of her medical condition was the reason she took so long to resign. Therefore, she said, she was unable to affirm the contract at an earlier stage because she wasn't well enough. In order to assess this position, an expert psychiatric report was commissioned jointly by the parties, and the report concluded that during the first period of sick leave, Ms. Mari had suffered from moderate depression, and during the second period, she'd been suffering from a severe depressive episode. As a result, the expert's report commented that it would have been, quote, extremely difficult, unquote, for Ms. Mari to have gathered the confidence and energy to bring legal proceedings. At trial, however, other evidence was also considered by the tribunal, and this included a letter produced from Ms. Mari's doctor, which commented that her depression was mild and she was prescribed treatment at a relatively low level of medication. Also, the tribunal was shown evidence that Ms. Mari had made annual trips to Ibiza to visit her parents during her sick leave, and she'd been well enough to obtain legal advice. Therefore, the Employment Tribunal dismissed her claim. It looked at all of the facts in the round and made an assessment as to whether Ms. Mari had affirmed the contract, and it came down on the side that she did indeed affirm the contract. In particular, the tribunal found that it did not matter that Ms. Mari had said in her earlier letter that she was, quote, reserving her position, unquote. This didn't prevent her from affirming her contract thereafter. Second, she had affirmed the contract thereafter by virtue of her repeated requests for access to the work email system, her acceptance of 39 weeks full sick pay, and her request to be considered for permanent health insurance, amongst other matters. In relation to the expert's report, the tribunal found that the expert, commissioned by the tribunal, did not appreciate the fact that she had taken legal advice during her sick leave, and the expert didn't comment on the fact that his diagnosis was severe depression, yet Ms. Mari was only on minimal medication from her GP. Overall, Ms. Mari's rare visit to the GP, plus her ability to travel and engage in correspondence, all added to the finding that she was capable of resigning on an earlier date, and therefore she had delayed too long. Well, no surprises, Ms. Mari appealed to the EAT. And her main ground of appeal was that she was simply too unwell to have affirmed her contract, and the tribunal had been perverse in finding otherwise, especially in disregarding the medical evidence and in respect to the jointly instructed expert. Ms. Mari also claimed that the employment judge had erred in law in relying on her acceptance of sick pay as evidence she'd affirmed the contract. Well, the EAT dismissed the appeal. The EAT decided the tribunal was entitled to find that she was not too ill to resign. There was ample material on which the tribunal relied in its findings that Ms. Mari was capable of resigning at an earlier date, but instead she had elected to affirm the contract. And the EAT placed particular weight on the fact that the expert opinion report was based on only 1 hour conversation with Ms. Mari, whereas the tribunal had had access to a number of other pieces of evidence, including a letter from her doctor, which detailed her medical history and which painted a fuller picture. In relation to the question of accepting sick pay as evidence of affirming the contract, the EAT was clear that whether it would be considered a factor in the affirmation of a contract would depend on the circumstances. At one extreme, an employee may be so seriously ill that it would be unjust and unrealistic to hold that acceptance of sick pay contributed to affirmation of the contract. On the other hand, at the other end of the picture, an employee might continue to claim and accept sick pay when they are almost better and when seeking to exercise other contractual rights. Claimant also ran a very technical argument. She asserted that where the claim was that the individual had been demoted, it was necessary to find that it accepted the new contract merely than affirmed the old contract. The EAT did not accept this as correct. The same test for affirmation applied, whether or not the breach was a demotion or some other type of breach. I think the key factor to bear in mind is that the continued acceptance of sick pay by itself is not necessarily an affirmation of the contract, but it may be. Clearly, a degree of common sense needs to be applied. There's a world of difference between a very sick employee and one who's only mildly incapacitated. It's necessary to look at the other actions that are going on at the time, and if the employee is calling for email access, for example, or is taking other actions that are consistent with their remaining as a contract, that's important evidence. An employer in that situation would be well advised to record that evidence as it arises, so that it is in the best possible position to argue the affirmation point down the road, if it becomes relevant. It is, of course, a commonplace in employment law that individuals often go on sick leave following problems at work. Stress and anxiety count for many such absences. Equally, if you're advising employees, the advisor needs to know the employee doing nothing may amount to an affirmation of the contract if they're accepting sick pay in the meantime, and it's not enough just to write a letter reserving your rights. The other aspect that I find interesting is that in this case it's the tribunal was willing to disagree with the jointly appointed expert because they'd only spent an hour with the individual, and the tribunal was prepared to back its own judgment based on the additional material which it had seen. That's fact-specific, but I thought it was an interesting aspect. So, that's the case of Colomar, Mari and Reuters Limited. Now, my second case is Smania, or Smania, I confess I don't know, and Standard Chartered Bank. Smania, we'll call them Smania. This is an EAT decision dealing with the territorial reach of the public interest disclosure rights contained in the Employment Rights Act, 1996. By way of brief background, there are provisions in the ERA relating to the protection of employees making public interest disclosures, and they're called in the shorthand the whistleblowing provisions, so that's what I'll do here. These whistleblowing provisions were subjected originally to Section 196 of the Employment Rights Act, which contained the territorial reach of the Employment Tribunal. However, Section 196 was repealed without replacement in 1999, and ever since their repeal, the tribunals have been left with guidance being developed by case law on the scope of their jurisdiction. The basic principles derived from case law are: the Employment Tribunal must ask whether Parliament can reasonably taken to have intended that the claimant should have the right to bring his or her claim before the tribunal, and, in the case of a truly expatriate employee who works and lives abroad, there must be a sufficiently strong connection with Great Britain and with British employment law. Now, as we mentioned in our last podcast, because of course this is now an ongoing theme, this is often a crucial battleground for claims. If an employee can establish the jurisdiction is in the English tribunal system, they may be in a very strong position. This could be particularly damaging for an employer, especially if the employer has handled a matter on the basis the individual had no English statutory claims. Most of the cases that have considered the scope of the tribunal's territorial reach have been in relation to ordinary unfair dismissal provisions in the Employment Rights Act. Therefore, this case is particularly interesting as it considers the territorial jurisdiction of the Employment Rights Act in the context of a claim for whistleblowing following an alleged public interest disclosure. The key facts of the case are that Mr. Smania is not a British national. He's Italian. He worked for Standard Chartered Bank in their Singapore branch. He resided in Singapore. He paid tax in Singapore. His contract of employment was governed by the law of Singapore, and he was dismissed in Singapore. In fact, the only connection that he had with Britain was that he'd lived for a period in Britain before being recruited to work for Standard Chartered, and secondly, most importantly, Standard Chartered Bank itself was his employer, and it had its headquarters in Britain. In other words, there wasn't a series of subsidiary companies. Everyone was employed by Standard Chartered Bank, or he was certainly. For the purpose of the tribunal process, it was assumed that the individual had made a protected interest disclosure. And he'd made it in relation to certain alleged malpractices at the bank, and it was assumed that he was subsequently dismissed as a result. Following the dismissal, he tried to bring a claim for whistleblowing in the English Employment Tribunal system, which is why we have the case we have here. Well, the Employment Tribunal first considered whether he had the right to bring such a claim. The test laid down by the case law for ordinary unfair dismissals was that he would have to prove that he had an especially strong connection with Great Britain and with British employment law. However, it was accepted by both parties, and surely rightly, that if this had been a case of an ordinary unfair dismissal, the Employment Tribunal would not have had jurisdiction to hear his claim. He clearly did not have a sufficiently strong connection with Great Britain or with British employment law. However, as Mr. Smania's case, that because he'd made a public interest disclosure, there could be a looser test so that he would be permitted to bring a claim under the Employment Rights Act. Therefore, the key issue which the tribunal had to determine was, assuming he'd made a public interest disclosure, did that warrant the use of a different test for jurisdictional reach? Well, the Employment Tribunal found it had no jurisdiction to hear his claim. It held that there was no reason to apply different tests in relation to different provisions of the ERA. The same test, they said, should apply to all the provisions of the Employment Rights Act. Mr. Smania appealed against the decision on two main grounds. He argued that a public interest disclosure engaged the right to freedom of expression under Article 10 of the European Convention of Human Rights and Article 11 of the EU Charter of Fundamental Rights. As such, he put forward the argument that because the UK courts were under an obligation to interpret UK legislation in the light of the European Convention on Human Rights and the Treaties of Europe, they ought to find that the Employment Rights Act could apply extraterritorially in order to protect those fundamental rights. Secondly, he submitted that Parliament must have intended for workers like himself to have protection from dismissal for making a public interest disclosure. This is because Mr. Smania's assumed complaints were about alleged banking practices adopted by the bank, and the bank was domiciled in the UK. Therefore, he said, he believed his disclosure was in the UK's public interest and the UK courts should construe the Employment Rights Act to make sure they had jurisdiction to hear such claims. Well, the EAT rejected the appeal. It agreed with the findings of the tribunal. In relation to the first argument, the EAT made it clear that any European legislation, whether from the treaties of the European Union or the European Court of Human Rights, has no effect in Singapore. Whilst the courts are under an obligation in some circumstances to construe UK legislation in order to give effect to EU law and convention rights, this was not appropriate in this case. The EAT firmly stated that reliance on EU law or convention rights does not confer jurisdiction on the UK where there would otherwise be none. Moving on to the second point, the EAT found that there was insufficient reason to treat the Employment Rights Act as extending the judicial territory for claims concerning a public interest disclosure, but not for other claims. According to the EAT, this has caused the courts to draw a distinction that is simply not apparent in the legislation. The bottom line was that the same jurisdictional test should apply across the board. The EAT felt confident in reaching this conclusion because when the public interest provisions were first introduced in the UK, they were included in the Employment Rights Act, which at the time was expressly limited by Section 196. When Section 196 had been repealed, no attempt had been made by Parliament to provide for a different approach to jurisdictional issues for whistleblowing complaints. So it's clear that employees raising public interest disclosure were only protected to the extent that their claim was raised in the UK or came within the sufficiently strong connection. Moreover, the EAT said if it were to allow him to bring his public interest disclosure claim, they'd be opening up the UK courts to a potentially very wide class of claimants, which they couldn't justify. In summary, the EAT found that although UK law does recognise the right of an individual to speak out on matters of public concern without fear or penalty, that right has precise boundaries, as evidenced by the intention of Parliament. The outcome of the case is unsurprising. If Mr Smania had been successful, then there would have been no clear limits to the provision of the Employment Rights Act in cases where there was a public interest disclosure. An employee of any origin based in any country would be able to rely on the rights under the Employment Rights Act if they were dismissed for making a public interest disclosure, so long as their employer was based in the UK. And this quite clearly goes beyond the limits that Parliament envisaged for the Act, I would suggest. Equally, considering the public interest disclosure legislation was amended last year, surely if Parliament intended the legislation to have a wide-ranging scope, it could have used this opportunity to build this into the statute. Practically speaking, if the EAT had decided differently, this might have also begged the question of whether tribunals would have to determine at an early stage whether the public interest disclosure did indeed have an impact in the UK, in order for the court to be willing to hear the claim. Overall, I'd say this is a welcome and sensible decision from an employer's perspective. The EAT haven't departed from the settled position on case law and have confirmed there's just one test for jurisdictional scope under the ERA. So, whatever the reason for the unfair dismissal, the test for jurisdiction is going to be the same. So, that's Smania, S-M-A-N-I-A, and Standard Chartered Bank. Now, the third and final case is DAS, D-A-S, and Ayrshire and Arran Health Board. This, the third of the three EAT cases, looks at the amount of compensation a job applicant ought to receive where the employer has subjected him to victimisation. And the case focuses on the extent to which any compensatory sum should be reduced to take into account the likelihood that the job applicant would have been successful at the interview, as well as other surrounding circumstances. And the case, well, it's interesting in two ways. First, factually, the way in which the relationship went sour and then resulted in multiple claims is practically a textbook example of how things can go wrong. And I mean that without criticism of any party. It just is one of those things, and you can see the train of developments in the story. Secondly, the EAT's views on compensation are very relevant for employers, and they are very helpful. So, by way of background, and I emphasise this is only a summary of a much longer and more twisty set of facts, Mr Das started employment with Arran Health Board in 2000 as a doctor who specialised in the care of the elderly. I think it's fair to say his employment with the Health Board was not without complications, and in 2005-06 he raised concerns about potential misdiagnosis of patients by a particular consultant. This was subsequently investigated, and the outcome was that there was no evidence to support his claims. Mr Das also raised concerns in 2007 that he was discriminated against on the grounds of his race. In October 2008, he made a complaint about another racist comment, and this led to a grievance procedure which completed in early 2009. In late 2009, he resigned, and he took up a number of temporary posts as a specialty doctor in various other points in Scotland. Some of the posts required him to live away from his family. April 2010, the Health Board publishes an advertisement for a specialty doctor, a post for a specialty doctor, I should say, in a hospital near Mr. Dass's home. Mr. Dass was qualified for the post and he applied. At the interview, however, when he was shortlisted, he was assessed as having performed badly. He was asked a question in the interview about underperforming doctors, and he became defensive and agitated, and in retrospect, apparently, it was because he thought he was being asked a question directed back to his complaint in 2006. Mr. Dass is also marked unsatisfactory in respect of his lack of appraisals and minimal training over the last few years. As such, another candidate was offered the post. Mr. Dass brought a claim against Arran Health Board in 2010, relying on the fact that he'd raised concerns in 2006 and raised a race discrimination grievance in 2008. This claim was settled. Well, in late 2012, you know what? Arran Health Board published another job advertisement for a specialty doctor, and Mr. Dass applied for the vacancy. As before, he was qualified for the post, and he was indeed the only applicant. Arran Health Board shortlisted him for the post, but prior to the interview, they withdrew the vacancy. Well, initially the proposal had been that the Health Board would put in place an interview panel for him which did not have knowledge of his prior history. They wrote to the claimant, explaining this is what they proposed to do. However, the somewhat legalistic nature of the response received from the claimant, in the board's view, and further concerns that were being expressed within the board led to a meeting at the end of January 2013. Separately, the board had been looking at a reorganisation of its service provisions. It turned out that the HR department of the Health Board thought there was a high risk of Mr. Dass bringing a claim for discrimination if he was not offered the post due to his history, when he was employed previously by Arran Health Board. Following the meeting on 31 January, Arran Health Board decided to withdraw the position before the interview stage had even been gone through, because of the potential for reorganisation, and so no interview panel was ever convened. Well, Mr. Dass brought a claim for unlawful victimisation under the Equality Act 2010, and his claim was that he wanted to be employed at a hospital within travelling distance from his home, and he suffered a large detriment in not being offered an interview by Arran Health Board, as they were the only employer in the region. The Employment Tribunal agreed with Mr. Dass that the Health Board had subjected him to victimisation. The reason he was not interviewed was because of the risk that he might bring a discrimination claim, and that had led to the meeting on 31 January, at which a consensus arose that it would be better not to proceed with the interview process. Therefore, the tribunal awarded him compensation. However, the most interesting part of the case relates to the compensation that was to be awarded. In deciding the exact amount of the compensation to be awarded, the tribunal considered a number of factors: the loss of the chance of Mr. Dass being appointed to the role, any financial loss he suffered as a result of the lost chance, and the injury to Mr. Dass's feelings. Well, with regard to the loss of the chance, the tribunal considered that Mr. Dass had performed badly in the 2010 interview, and therefore there was no guarantee that had he received an interview, he would have obtained the role. Bear in mind he's the only candidate for the role. It also found that Arran Health Board was prepared to turn away all unsatisfactory candidates, even if that meant no appointment was made. Also, the tribunal held that it was likely that any interviewing panel would have been concerned about Mr. Dass's series of temporary roles and would have inquired about the reasons for his previous departure from the employer. So, on consideration of the evidence before it, the tribunal found that Mr. Dass only had a 10% chance of being appointed to the role, and therefore his compensation award was reduced by 90%. In relation to the financial loss, the tribunal also held that Mr. Dass didn't suffer any financial loss, as he was earning the same salary in his existing job. When considering the amount to be awarded for injury to feelings, the tribunal granted Mr. Dass £5,000 on the basis that he failed to obtain the position closer to his home, and given the nature of his position, he was restricted to the Arran Health Board as the potential employer in that area. Mr. Dass appealed against the 90% reduction in compensation and argued that the tribunal's findings were perverse. Arran Health Board cross-appealed on the pain and suffering award. Well, the EAT dismissed both appeals. The EAT held that the tribunal was entitled to find that Mr. Dass had only a slender chance of appointment to the role, and he was entitled to reduce the compensatory figure accordingly. The tribunal judge had given clear reasons for the decision on the sums awarded for injury to feelings and for future loss. According to the EAT, there was no error of law. In summary, the EAT agreed that, as Mr. Dass was not very likely to obtain the position, the value of the compensation had to reflect this. And in this context, I think this was a very important finding, that the tribunal was prepared to find as a fact that the Health Board would prefer to decline to appoint anybody than appoint someone who is not suitable for the role. Secondly, the tribunal accept the interview panel would have asked about his career history, and he would have answered it honestly, and presumably that would have reflected badly on him. So this as well would have had an impact on the likelihood of him receiving the new role. Well, the tribunal's decision inevitably involved a certain amount of speculation on its part, given that no interview panel had ever been put in place, because no one had ever actually been interviewed for the role. So there could, by definition, be no evidence as to how people had reacted in the interviews, or what questions would normally have been asked. So the tribunal's willingness to look back at previous interviews involving the claimant was very sensible. Equally, in our experience, often claimants and their advisors focus on the liability and the alleged wrongdoing without stopping to think about the quantification of the claim from the start. It's amazing how many times I bring lawyers on the other side and ask them, very early on in the process, what their client is seeking by way of remedy or recompense, and the lawyer just doesn't seem to have considered that topic. Additionally, the tribunal were entitled to award a relatively high amount for injury to feelings, and the amount wasn't so excessive that it required reconsideration. It was acceptable that £5,000 was awarded for the anger, upset and humiliation arising from the loss of a job opportunity because of an earlier claim that Mr. Das had brought. Well, the case is helpful in outlining a tribunal's approach to assessing compensation for victimisation. Although a 90% reduction in the amount of compensation is quite unusual, it's not particularly surprising on the facts of this case, as there are numerous reasons why Mr. Das may not have obtained the role in question. This aspect of the case is encouraging for employers, as it shows the tribunal's willingness to make a reduction to reflect the possibility the applicant wouldn't have been successful in any event. Looking at the case here, I think the Health Board were clearly trying to do the right thing, and so the idea of a panel being empowered, which has limited knowledge of the claimant's background, and then writing to explain to the claimant why they're doing this, well, that's obviously a good and sensible step. But where the tribunal found the employer had substantially gone wrong was in withdrawing the opportunity for the interview altogether, based on the need for reorganising the roles. The case also serves as a useful reminder for employers that they will face the risk of a victimisation claim if they do not hire someone on the basis that the job applicant might bring a discrimination claim. An employer won't necessarily be saved by arguing there were other reasons for not offering a person the job, so long as the protected act can be identified as a reason. So, that's the case of Das and Ayrshire and Arran Health Board. Thank you for listening. I said I'd simply mention, and I will do it just briefly, the launch of the podcast on YouTube. Don't worry, it's not a video feed of this podcast. It's another way of launching the audio file only. But we felt that some people may prefer to access the podcast at work, for example, lunch break or something, and it's easier to do that on YouTube than it is to download iTunes, where there's still some firewalls that prevent that. So please do look up the Employment Podcast on YouTube. It's going up on Friday. By the time you hear this, it's going up the same day as this podcast is being put on iTunes. I'm recording this on the Wednesday afternoon, and this afternoon there is a short, one-sided interview, me talking to camera about the podcast and why we do it and what we're hoping to achieve and so on. So do look that up as well. Any comments, polite or otherwise, please do send them through to me, nrobertson@mayorbrown.com. I think the only thing that remains for me to say is thank you very much indeed for listening. I look forward to speaking again sometime soon, and take care, everyone.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.